Okay, yeah, ready to go.
All right. Welcome everyone to our webinar under the title "On the Table of the ICJ, the Legality or Illegality of the Israeli Occupation and the Subsequent International Responsibility." This webinar will be held fully in English. However, we have Arabic interpretation. So allow me to say a few words to our Arabic-speaking audience. أعزائي المتابعين باللغة العربية، ستعقد هذه الفعالية باللغة الإنجليزية، فالرجاء منكم الضغط على إشارة الكرة الأرضية في أسفل الشاشة إن أحببتم الاستماع للترجمة العربية، وبإمكانكم طرح الأسئلة في خانة المحادثة في الأسفل أو رفع اليد وسنقوم بترجمة الأسئلة للغة الإنجليزية. وشكرا لكم. Welcome again everyone. This is Hassan bin Imran, a board member at Law for Palestine, joining you from Nairobi. This event is organized by Law for Palestine in partnership with ARDD, with whom we are collaborating in the second season of the Jurist Forum. I would like to welcome you all in this Zoom room, those watching us in the live stream, and our 1,200 members of the Jurist Forum. Today, we will be talking about the UNGA resolution rendering upon the ICJ to decide upon the legality of rendering upon the ICJ to deliver an advisory opinion on the Israeli occupation and the legal status of which in the OPT, and to decide on the legal consequences arising from the ongoing violation of the Palestinian right to self-determination, and the legal consequences that arise to all states or for all states and the United Nations based on this status. We will also be talking about the findings of the UN Commission of Inquiry on the illegality of the Israeli occupation or the legal status of the Israeli occupation in the OPT. We're starting with our first speaker, Mr. Miloon Kothari, to talk about the findings of the Commission of Inquiry, especially those regarding to the legal status of the Israeli occupation in the OPT. Mr. Kothari is a member of the UN Commission of Inquiry on Palestine and Israel. He served from 2000 to 2008 as the UN Special Rapporteur on Adequate Housing. He was also a convener or the convener of the Working Group on Human Rights in India and the UN from 2009 to 2014. And he was a visiting scholar at MIT from 2013 to 2014. Mr. Kothari, the floor is yours. You have up to 12 minutes. Please go ahead.
Okay, thanks very much, Hassan, and hello, everyone. You've already introduced the commission, so I just wanted to say, for those of you who are not familiar with the work of the UN Commission of Inquiry, it was established following the terrible 2 weeks of violence in May 2021, following a special session of the UN Human Rights Council, which led to a resolution, which led to the formation of our Commission on Inquiry. There have been a number of commissions and fact-finding on Palestine in the previous years, but given the current very adverse situation, I just wanted to point out that there are some sort of redeeming or unique features of our commission, which I think make it possible for us perhaps to make a small contribution to the resolution of the crisis in the region. One of them is that we are an open-ended mandate, so there is no end to the commission. Unlike previous commissions, which had to be mandate had to be renewed every year, ours doesn't have to be. And the second is the temporal scope. We are supposed to look at root causes and also the reasons behind the perpetuation of the conflict. There is a very broad geographic scope. Unlike all previous commissions, our commission also is mandated to look at the situation inside the Green Line, which allows us to look at also the situation of Palestinians inside the Green Line. We also have a very broad thematic scope, which covers a range of human rights, but it also covers humanitarian law, it covers criminal law, the resolution calls for us to establish legal accountability, and I quote, legal accountability, including individual criminal and command list responsibility. The manner of working for the Commission is we have 2 reports annually, one to the Human Rights Council and one to the General Assembly. So we've done 2 reports. In addition to that, we are holding a series of public hearings. Some of you may be familiar with those, looking at the situation of the designated terrorist NGOs, so-called terrorist NGOs in Palestine, but also we are looking at the threat to journalists and lawyers and others. And we've held a series of roundtable expert meetings with a range of Jewish and Palestinian scholars to advise us on the work. So our first report to the Human Rights Council, actually, we're trying to implement the mandate and we were asked to look at, draw out the essence of all the previous work done on Palestine, not only from commissions of inquiry and fact-finding, but also by special rapporteurs, by treaty bodies in the Universal Periodic Review, and so on. In conducting that review, the COI noted that many findings and recommendations relevant to the underlying root causes related to Palestinian entities and armed groups, but the vast majority were directed towards the state of Israel. And we confirmed that, confirming the asymmetrical nature of the conflict and dispelling the view that there are 2 parties on an equal footing and reflecting the reality of one state occupying another. The report concluded that there was a state of perpetual occupation of Palestine and long-standing discrimination in both Israel and Palestine as a core underlying root cause of the violence. And there were constant threats of forced displacement, demolition, settlement construction, and so on. That was just a very quick summary of the first report. In the second report, we actually went further and stated that occupation was a core underlying root cause of conflict, and that de jure and de facto annexation, the policies employed have become irreversible on the ground, while hiding behind, and we say, a fiction of temporariness, and the human rights implications for Palestinians and severe implications, legal consequences of such actions. So the COI concluded that there were reasonable grounds to conclude that the occupation was now unlawful under international law due to its permanence, and action taken to annex part of the land de jure and de facto, with these actions being taken by Israel being the intention of maintaining permanent occupation. We also noted that it is unclear under international law and practice when a situation of belligerent occupation becomes unlawful, as by definition under international law, it must be a temporary situation and cannot imply any right of sovereignty over it by the occupying power. So in the consideration of the facts in the first report, this COI noted that the ICJ had anticipated the scenario in its 2004 advisory opinion on the wall, in which it laid out that the wall was creating a fait accompli on the ground that could well become permanent and tantamount to de facto annexation. It concluded that this scenario envisaged by the court, we concluded, has now become a reality, not just in relation to the construction of the wall, but rather in relation to all policies being employed to ensure the permanence of the occupation. So we carefully reviewed all the findings of the ICJ 2004 advisory opinion, which found also that, coupled with establishment of settlements, the construction of the wall and its associated regime were tending to alter the demographic composition of the OPT, thereby contravening the Fourth Geneva Convention and relevant Security Council resolutions, and that we found that Israel was in breach of its obligation to respect the right of Palestinian people to self-determination. So we noted that it's of great importance, particularly given our mandate to make recommendations for states to respect international law and fulfill the obligations under the Fourth Geneva Conventions, that the advisory opinion should be sought, which lay down the legal consequences of other states, so third-party accountability, and holding that all states were under an obligation not to recognize the illegal situation. And we found in our report that the illegality of the occupation and the relevant jurisprudence from the ICJ's 2004 advisory opinion, despite its narrow scope, including on the anticipated scenario of de facto annexation, a clear refusal by Israel to end the occupation, and the obvious unclarity in international law on when a belligerent occupation becomes illegal. The commissioner decided that it was vital, and that was our recommendation in our report to the General Assembly, that the General Assembly asked the ICJ to revisit and expand on its 2004 advisory opinion, laying out the legal consequences of Israel's refusal to end the occupation and respect the Palestinian people's right to self-determination, as well as make clear that the legal obligations of third states and the UN are what they are to ensure respect for international law. I think, as we all know now, the ICJ, things have moved very fast since we made that recommendation in our report. And the ICJ is now seized of the matter, and we remain seized of the matter as well. And I'm happy to answer some questions. Thank you very much.
Thank you so much, Mr. Kothari, for this intervention. We would love to hear more from you about this in the Q&A session. We will move now to our second speaker, Dr. Giulia Pinazauti, who will touch upon the ICJ's jurisdiction in this case, including the opposing perspectives. Dr. Pinazauti is a professor of international criminal law at Leiden University. She has broad experience in the law and practice of international courts and tribunals. She worked with the ICJ, ICTY, the appeals chamber at the Special Tribunal for Lebanon, among others. Dr. Giulia, the floor is yours. You have up to 12 minutes, please.
Thank you very much, Hassan, and good evening, everyone. In the time that I have, I will try to address two main issues: the court's jurisdiction to give the opinion requested by the General Assembly, and then I want to touch on considerations of judicial propriety, and I will focus in particular on whether the court can issue an opinion given Israel's lack of consent to adjudication, which is an argument that is very likely to be raised during the proceedings, in my opinion. So starting with the court's jurisdiction, for those who are not familiar with it, there are two statutory criteria that regulate the court's jurisdiction to render an advisory opinion in the statute and the UN Charter. First, the court can only reply to legal questions. And second, only authorized bodies can submit a request. And if we look at these two criteria, in my view, there is no question that the court has jurisdiction to give the requested opinion on the legality of the occupation. Under the UN Charter, the General Assembly is authorized to request an opinion on any legal question. And even if the two questions that were asked by the General Assembly relate to what is a deeply politicized situation, they're undoubtedly legal questions. They're framed as questions of law and presuppose an answer that is based on the application of international law. And the court stated in another opinion that the fact that political considerations are prominent in a given situation doesn't militate against the court's jurisdiction to render an opinion. To the contrary, clarifying the legal principles applicable in that situation may be particularly necessary. And I think this also applies in this case. Turning now to judicial propriety, the court's statute in Article 65 states that the court has discretion to declined to give an opinion that falls within its jurisdiction. This is a discretionary power that is not regulated in the statute. In its past jurisprudence, the court has said that it may decline to give an opinion to protect the integrity of its judicial function. But it also characterized its opinion as its participation in the activities of the UN, and it said that in principle, the court should not refuse such participation unless there are compelling reasons to do so. The court has only spelled out one such compelling reason, and that is the lack of consent of an interest state that may render the giving of an advisory opinion incompatible with the court's judicial character. And for example, this is the case when the court said to give a reply would have the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to adjudication without its consent. Consent, as we know, is a prerequisite for the court's contentious jurisdiction. But a recent practice, I think, suggests that states increasingly use advisory proceedings to bring before the court contentious matters in situations where the other state doesn't consent to the settlement of the dispute before the court. If we look at the opinions that were issued in the past 20 years, this happened in 3 out of 4 opinions. And we know that in this case, Israel doesn't consent to the settlement of any disputes with Palestine before the ICJ. And some states, scholars, even members of the ICJ, including the president, have voiced concerns that this practice circumvents the principle of consent to adjudication, and that the court should decline to give the opinion requested in such circumstances to protect the integrity of its judicial function. And I think we'll hear similar arguments during the proceedings. For example, already in the explanation of vote on Resolution 77247, the representative of the UK already pointed out that it's inappropriate without the consent of both parties to ask the court for an advisory opinion on a bilateral dispute. So how should the court deal with these arguments? Well, the court has actually never declined to give an opinion based on considerations of judicial impropriety, even when the request related to a pending dispute. For example, this was the case in interpretation of peace treaties, Namibia, Western Sahara, in the Mazilu case, in the Wall, Kosovo, and more recently in Chagos. Only on one occasion, the court's predecessor, the Permanent Court of International Justice, declined to issue an advisory opinion on a question that concerned, quote unquote, directly the main point of the controversy between the parties that were Finland and Russia. And the court stated that answering the question would be substantially equivalent to deciding the dispute between the parties. But I think in that case, there were also other considerations at play. In the circumstances of that case, giving the opinion would have required the consent and cooperation of both parties because the question before the court was very much factual. And Russia was neither a party to the statute of the Permanent Court, nor a member of the League of Nations. It objected to the proceedings and refused to participate. So the court lacked factual elements to issue the opinion. The present court has never overruled this precedent, but always sought to distinguish it on the facts. And I think this won't be a problem in the case of the opinion on the legality of the occupation, because Israel, like Russia in Eastern Karelia, is a UN member state, is a party to the court's statute. So we can argue that it has given its consent in general to the exercise by the court of its advisory jurisdiction. The other relevant consideration is that the court has progressively narrowed down the relevance of consent to advisory proceedings in 2 ways. First, by saying that the opinion requested doesn't concern a legal dispute. For example, in Namibia, said that the fact that the court may have to pronounce on legal issues upon which the parties have radically divergent views doesn't convert the case into a dispute. And this was also repeated in Chagos in 2019. There, the court held that it wasn't dealing with a bilateral dispute about sovereignty, but with a question of colonization, which is true, but at the same time, ruling on the illegality of the decolonization process inevitably impacted on British sovereignty over Chagos. So to put it bluntly, if the court wasn't dealing with a bilateral dispute in Chagos, I think it's unlikely that it will reach a different conclusion in the opinion on the legality of the occupation. We can say that the request relates to question in dispute between Israel and Palestine or between Israel and other states, but it's not upon a legal question that is actually pending between two or more states. The only issue that I see might be the breadth of the questions that were asked to the court. Second, the court has limited the relevance of consent in advisory proceedings by placing the dispute in their broader framework, as the court calls it. And here the court looks at the object and the nature of the request. For example, in the Wall opinion, it didn't consider that the subject matter of the opinion can be regarded as only a bilateral matter between Israel and Palestine, given the UN's permanent responsibility towards the question of Palestine. And the court held that the question was located in a much broader frame of reference. In other cases, the court looked at whether the opinion was meant to guide the action of the General Assembly or Security Council in the performance of their own functions, rather than to assist them in the settlement of a bilateral dispute. So if we apply these principles to this opinion, we can argue that the questions put to the court concern issues that are located in a broader frame of reference than the settlement of a purely bilateral dispute, like the court said in the Wall advisory opinion. And the subject matter of the request, I think, goes beyond a bilateral dispute, because it prompts the court to examine the necessity and proportionality of the occupation under the jus ad bellum, whether the conduct of Israeli authorities breaches relevant rules of international law, including the right to self-determination, in a way that affects the legal status of the occupied territory. And self-determination of people, as asserted by the court, creates erga omnes obligations for the entire international community. So this is not a purely bilateral matter. Another argument is that the General Assembly asked the opinion of the court to inform its own work on Palestine. In this case, the request arose from the work of the Special Political and Decolonization Committee, which covers Israeli practices and settlement activities affecting the rights of the Palestinian people as part of its agenda items. And finally, one could also argue that the General Assembly didn't seek the court's opinion to exercise its functions in the settlement of a bilateral dispute, although maybe this is a somewhat more difficult argument to make. For example, the court didn't go there in the Wall advisory opinion. Other arguments, very briefly, that could be raised are, for example, that the opinion could impede a political solution to the conflict. And we already know that the adoption of Resolution 77 was accompanied by calls that the initiative will harm regional stability, the prospects for a future agreement between Israel and Palestine, or that the court will not have before it sufficient information and evidence to arrive at a judicial conclusion on complex factual matters. But these were arguments that were already advanced in the Wall advisory opinion and rejected by the court. So I think they will equally be dismissed. So to conclude, in my opinion, the court has jurisdiction to give the opinion requested, and there are no compelling reasons why the court should decline to give the opinion requested. by replying to the request, the court would not only remain faithful to the requirements of its judicial character, but also discharge its functions as the principal judicial organ of the United Nations. So for me, the real question is what the court will actually say in answering the request and how far it will go. Thank you very much.
Thank you so much, Giulia, for the very, let's say, enlightening thoughts you have shared with us. I would like to share that with you that Giulia is writing a blog about this topic as well. We're looking forward to reading it, hopefully soon. So thank you for your intervention. Now we move to our third speaker, Dr. Ralph Wilde, who will talk about the legality or illegality of the Israeli occupation in the OPT. Dr. Wilde is an expert in international law and a member of the law faculty at the University College London, in the University of London, and a consultant on international law matters to states, international organizations, and NGOs. He previously served on the executive bodies of the American and European Societies of International Law and the International Law Association. He provided expert legal opinions to the PLO negotiators, among others. Dr. Ralph, the floor is yours.
Thank you very much. It's a pleasure to be with you. On the day that the General Assembly voted to make its request to the court, I published a legal opinion explaining what it means in international law to characterize the Israeli occupation of the Palestinian West Bank, including East Jerusalem and Gaza, as illegal. In other words, what the court will have to determine on that crucial question. And my opinion is partly based on my academic publications on the subject, which include an article published a week before the General Assembly vote entitled Tears of the Olive Trees, Mandatory Palestine, the UK and Accountability for Colonialism and International Law, published in the Journal of the History of International Law. And another article published 12 months before that entitled Using the Master's Tools to Dismantle the Master's House, International Law and Palestinian Liberation, published in the Palestine Yearbook of International Law. Links to the opinion and these publications will be posted in the platforms for this event, and a thread summarizing my opinion and also including these links is a pinned tweet on Twitter at Ralph Wilde. What I'd like to do now is present that summary of the legal position. My legal opinion clarifies what the terms legal and illegal mean in relation to the occupation, as I say, of the Palestinian West Bank, including East Jerusalem and Gaza in particular, according to the relevant multiple areas of applicable international law. I explain how the different forms of legality or illegality relate to each other and how they apply to the occupation. In each areas of law, I explain what difference ending illegality would make. So, for example, ending abuses, preventing annexation, and ending the occupation itself. I also explain the meaning and significance of the various terms or areas of international law commonly invoked in this context: self-determination, settler colonialism, the jus ad bellum, or the law on the use of force and aggression, occupation and prolonged occupation, statehood, sovereignty, title to territory, annexation, apartheid, the jus in bello, the law of armed conflict, or international humanitarian law, IHL, or the laws of war, including occupation law, international human rights law, international criminal law, including the crimes of aggression, war crimes, crimes against humanity, the crime of apartheid, and the crime of torture, United Nations law, and the law of treaties. Yes, indeed, all those areas of international law need to be applied in order to address this question. Now, legality or illegality can refer to the existence of the occupation or its conduct or both. As to existential legality or illegality, the occupation, simply by virtue of exercising control over the West Bank, including East Jerusalem and Gaza, consequently preventing the Palestinian people from full and effective self-governance, constitutes a fundamental impediment to the realization of the right of self-determination enjoyed by the Palestinian people in international law. The only basis such an impediment could be legally justified is according to the law on the use of force, the jus ad bellum. Assuming hypothetically, and this is a big assumption, that Israel had a right of self-defense in international law in 1967 that justified legally the introduction of the occupation then, this justification has not persisted, nor has an alternative legal justification arisen. There has been no actual or imminent armed attack justifying as necessary and proportionate the occupation as a means of self-defense. And the doctrine of preventative self-defense, which would justify the occupation as a means of stopping a threat from emerging, has no basis in international law. Neither United Nations Security Council Resolution 242 nor the so-called Oslo Accords provide an alternative legal basis for the existence or the continuation of the occupation. Indeed, the Oslo Accords, as I explained in the opinion, are themselves violative of international law because ostensible consent to them by the PLO was, of course, coerced through the illegal use of force, the occupation. And relatedly, they conflicted with norms of international law that have a special non-derogable Jus Cogens status. That's to say, the prohibition on the use of force other than in self-defense and the right of self-determination. More generally, there is no international law right to maintain the occupation pending a peace agreement, and/or as a means of creating facts on the ground that might give Israel advantages in relation to such an agreement, and/or as a means of coercing the Palestinian people into agreeing a settlement to the situation that they would not accept otherwise. The consequence of the foregoing is that there is no valid international law basis for the existence of the occupation, pure and simple. In consequence, the occupation is an unlawful use of force, an aggression, and a violation of the right of self-determination of the Palestinian people on the part of Israel, and in the case of aggression, also a crime on an individual level for senior Israeli leaders. As a result, the occupation is existentially illegal and must end immediately. Legally, the requirement of termination is not contingent on particular circumstances being present. Specifically, the following factors or conditions cannot be by themselves a pretext for delaying termination. Willingness or consent by Israel, the adoption of a peace agreement, the adoption of standards within or the giving of undertakings by the Palestinian people, approval by the United Nations, the Quartet, or other states. In consequence, every day the occupation continues is a breach of international law. The existential illegality of the occupation arises out of the simple fact of the occupation as a system of control and domination without a valid legal basis. This is then compounded by the occupation's prolonged duration, its link to de jure and de facto annexation, and the egregious abuses perpetrated against the Palestinian people. The use of military force to annex territory is also an independent basis for existential illegality, also a violation of the international law on the use of force, and so also an aggression at both a state level and in terms of individual criminal responsibility. By contrast, the prolonged length of the occupation and its abusive nature are not independent bases for existential illegality, but are relevant as aggravating factors to the question of existential illegality as a matter of the law on the use of force. The abusive nature is also, of course, relevant to the separate matter of illegality of conduct. Any purported annexations are also without legal effect, because in international law, Israel is not and cannot be sovereign over any part of the West Bank or Gaza, including East Jerusalem, through the assertion of a claim to this effect based on the exercise of effective control enabled through the use of force, and in the absence of consent to such annexation freely given by the Palestinian people. Now, as to the legality or illegality of the conduct of the occupation, there are multiple egregious breaches of the relevant areas of applicable international law here. The laws of war, the law of armed conflict, jus in bello, or international humanitarian law, including occupation law, international human rights law generally, and within this, the prohibition of racial discrimination generally, and the prohibition of apartheid in particular. These are, again, breaches at the level of the State of Israel, and also, in some cases, individual crimes. War crimes, crimes against humanity, the crime of apartheid, and the crime of torture. The occupation is thus illegal in both its existence and its conduct. And in both cases, this gives rise to both state and individual criminal responsibility. One final point to make is that all the main areas of international law violated here, the prohibition on the use of force other than in self-defense, or put differently, the prohibition of aggression, the right of self-determination, the prohibition of racial discrimination generally, and apartheid in particular, a subset of the protections in IHL that are violated, and in particular the prohibition of torture. These are all norms that have the special non-derogable Jos Kogan status that I mentioned earlier in connection with the Oslo Accords. Jos Kogan's, or non-derogable status, is not a separate category of substantive international legal rules, but is rather a way of characterizing certain rules as being of a special character when it comes to their interaction with other rules of international law. Thank you.
Thank you so much, Ralph, for this very straight-to-point intervention. I would like to notify you that the articles Dr. Ralph mentioned will be shared in the chat box down there. And for those watching on live stream, you will see them in the comments of the live stream on the social media pages. Now we will move to our final speaker, Dr. Susan Power, who will speak about the consequences of the awaited ICJ advisory opinion, especially with regards to third states' responsibility, as well as the UN responsibility towards this opinion. Dr. Susan is the head of legal research and advocacy in Al-Haq. She lectured law for 7 years in Griffith College Cork and Dublin in Ireland between 2010 and 2017. She has a long experience in law-based advocacy, working on the Occupied Territories Bill in Ireland and with the International Law Commission, the ICC, and others. Susan, the floor is yours.
Thank you very much. And thank you, Hassan and to Law for Palestine for the invitation to speak today on this panel. I really appreciate it. And I'm going to speak about the consequences of the awaited ICJ advisory opinion and the illegality of the Israeli occupation, and especially with regard to state responsibility. I won't repeat what my distinguished colleagues have already very succinctly presented, but only to carry on from the argument which was presented in Ralph's presentation, that the occupation is illegal, jus ad bellum, and constitutes an unlawful act of aggression. But first, I will delve a little into the responsibility of Israel. So before I start, it should be noted that Article 18.3 of the International Law Commission draft articles speak to continuing crimes, whereby the international obligation for that state continues in force only in respect of the period during which the act continues. And this is particularly useful for gauging whether, for example, acts which have originally been lawful may over time become unlawful. And this is due to an obligation which is partly in operation for the state. So according to the ILC commentary to Article 18.3, the simplest characterization of a continuing unlawful act is the unjustified occupation of the territory of another state. So, for example, if we say that the occupation followed an unlawful aggression in 1967, consequences would arise from the continuation of an internationally unlawful act. And similarly, one could wage in relation to a self-defense argument that at a minimum, even if Israel's original use of force was a legitimate act of self-defense, like in response to an armed attack, we can say that Israel's continued belligerent occupation of the Palestinian territory for almost 56 years and decades after it concluded peace agreements with Egypt in 1973 and with Jordan in 1994, and also decades after the UN Security Council issued calls for its ending and withdrawal, highlights that the belligerent occupation really has exceeded all parameters of military necessity and proportionality, and it incurs state responsibility as an internationally wrongful act. And there are a number of important customary international law consequences that flow from the breach of an internationally wrongful act. And these include the obligation to cease that act if it is continuing, and also to offer appropriate assurances and guarantees of non-repetition. And also a state is responsible and obliged to make restitution. So that it should re-establish the situation which existed before the wrongful act was committed. So, for example, some jurisprudence on this, and as already mentioned in the Namibia case, the International Court of Justice held that South Africa had an obligation to withdraw its administration from the territory of Namibia. We've also seen more recently in the Chagos Islanders case that the British administration of the Chagos archipelago was to end as rapidly as possible. So in the case of Israel, we could see similar recommendations to withdraw the military administration from the territory. And it is important to note that the UN General Assembly has adopted numerous resolutions over the years calling for Israel's unconditional and total withdrawal. And this meaning that the withdrawal is not to be made the subject of negotiation, but rather it is to be terminated completely because it is an internationally wrongful act. But there are also, secondly, consequences that arise for third states, including that of non-recognition of the internationally wrongful act. So as Article 40 Part 2 of the draft articles on state responsibility provides no state shall recognize as lawful a situation which is created by a serious breach of peremptory norms of international law, nor render aid or assistance in maintaining that situation. And we saw this in the Wall advisory opinion, where the International Court of Justice considered that legal consequences arose for all states who were under an obligation not to recognize the situation which had arisen from the construction of the wall, and not to render aid or assistance in maintaining that situation, and to cooperate with the view to putting an end to the alleged violations and to ensuring the reparations will be made. And we can look to both international and domestic cases as to what those obligations more specifically entail. And again, turning to the Namibia advisory opinion, I suppose one of our most important cases, which is specifically on illegal occupation, and the International Court of Justice there provided that third states were obliged to abstain from entering into treaty relations with the occupying power, where it purports to act for the ousted occupied sovereign, and also to remove all diplomatic, consular and special missions, both to the territory of the occupying power and the jurisdiction of the occupying power in the occupied territory. And it also called on third states to abstain from entering into economic and other forms of relationship or dealings with South Africa on behalf of or concerning Namibia. And we've also seen domestic case law on this. So there was a World War II case of Amstel Bank versus Guarantee Trust Company of New York, and the United States government's non-recognition of the German military control of Holland had implications in that case for nationals and private entities of the occupying power, such as the invalidation of acts of withdrawal of cash or securities on deposit in banks in the United States. So we can see there's quite a wide range of legal consequences that arise. And there's also an important explanation in the commentaries to the draft articles, which suggests that the resolutions of the UN Security Council, for example, express a general idea which is applicable to all situations created by serious breaches in the sense of Article 40 on peremptory norms. So here the International Law Commission gives the example of a UN Security Council resolution which prohibited any aid or assistance in maintaining the illegal apartheid regime in South Africa. So here we can extrapolate from UN Security Council resolutions and potentially also UN General Assembly resolutions, measures of general applicability, whereby third states not render aid or assistance in maintaining an illegal situation, particularly in reference to the violation of peremptory norms of international law. And we can draw here from a myriad of UN Security Council resolutions and UN General Assembly resolutions on situations of illegal occupation. And there's been so many over the years in relation to Namibia, Angola, Kuwait, Azerbaijan, Kampuchea, and Guinea-Bissau, and many more. But we're just drawing a few by way of illustration. So, for example, there has been requests from the UN Security Council on all states to prevent imports or conduct any commercial, industrial, or public utility from an aggressor occupying power in relation to the Iraqi occupation of Kuwait. We've also seen requests on third states to desist from providing any military assistance and to prevent the sale and supply of military equipment, including materials for the manufacture of weapons and ammunition. And this was directly in relation to Portugal's illegal occupation of Guinea-Bissau, and similar calls on all governments to cease flights over occupied territory in violation of its sovereignty. And again, this call in relation to Turkey's occupation of Northern Cyprus. But in recent years, we've also seen third states and intergovernmental organizations applying countermeasures. And this is not specifically provided for in the draft articles, but it is developing in terms of state practice. So, for example, the EU responded with restrictive measures against Russia's unprecedented and unprovoked military attack against Ukraine with individual sanctions, economic sanctions, and diplomatic measures. And likewise, we saw the United States react against Russia's war of aggression against Ukraine, again with a list of sanctions, denying exports to military end users in Russia and Belarus and adding them to the Department of Commerce's entity list. And then thirdly, we'll also look at international responsibility of the United Nations, which has permanent responsibility with regard to the question of Palestine.
Apologies for interrupting you, Susan. Could you please slow down for the interpreters? They have been sending the group.
Oh, absolutely. So thirdly, we'll look at the international responsibility on the United Nations, which has permanent responsibility with regard to the question of Palestine. And this responsibility is until the question is resolved in all its aspects in accordance with international law and relevant resolutions. So matters such as the resettlement into Palestine of returned Palestinian nationals may be an issue that the International Court of Justice addresses to the UN General Assembly. And this would be for the completion of decolonization. And this would include calls for the cooperation of all states in this regard. And we've seen some case law on this already in the Chagos Islanders case. And we can take, for example, also the Namibia advisory opinion. And there, the International Court of Justice instructed the United Nations on its role in terminating the occupation. And this included the withdrawal of South Africa's troops in consultation with the United Nations and the substitution of the UN in its place. And also importantly here, a plebiscite to be held under UN supervision. And we can also look at the aftermath of Iraq's occupation of Kuwait. And there was a high-level coordinator appointed to report to the UN Security Council on the repatriation and return of Kuwaiti nationals and the return of Kuwaiti property. So we could see, and hopefully would see, similar measures and obligations outlined in relation to Palestine. And this would be very important, especially for issues around return and repatriation of property. And noting as well that UN Security Council Resolution 2334 already urges without delay international and diplomatic efforts to end the Israeli occupation that began in 1967. So just to conclude, a finding on the status of occupation would provide legal clarity on the steps and the legal consequences for deoccupation and full decolonization. And for Palestine, we just need to reiterate that this really is existential. So it is imperative that third states would fully commit to this process and that the International Court of Justice also work towards advancing the calls of the Palestinian people for full self-determination and their right of return, and take all necessary steps to dismantle Israel's military administration of the occupied territory. Thank you.
Thank you so much, Susan, for the rich intervention, and thank you for all our speakers for everything they contributed with today. It's been a very rich discussion, and now the floor is open for discussion. You may either raise your hand, like Dr. Mu'taz just now, type your question in the comments in the chat box, or share your comments with us, whether through the chat box or directly by raising your hand. And please, I would like to notify you about the time constraint, so we may have more participants participating in the discussion. So I will start with Dr. Mu'taz. please.
So thanks to all the speakers and to the Law of Palestine, Law for Palestine team for picking this very timely and interesting topic. And I could see that there is always, it has been always 100 participants throughout the session, which means that this topic is really, really interesting. I have a question to Miloon, and I'm really happy to see you, Miloon. I don't know if you remember me. We met 20 years ago when I was the head of OHCHR office in Ramallah, where when you prepared your report on the right to adequate housing, which was really one of the best reports in the history of the UN special procedures. And I think as Palestinians, we are very happy to have you as a member of the Commission of Inquiry. And I think the idea of referring the case to the ICJ is a really brilliant opinion. And my question to you is, what other brilliant ideas on the table of the Commission of Inquiry for the future? I'm not asking you to reveal any secrets, but if there are some interesting issues, it would be great if you can mention some. My other question is to Giulia or maybe to Ralph regarding the composition of the court and the politics of the court. I remember Professor George Abisab, when he was the representative of Palestine at the ICJ whole case, he said, you know, we were uncertain about what the court would say until the last moment. Although we know that the court rendered its opinion with 40 with and one against only. So in this, I don't know if we have studied the composition of the courts and opinion of judges from their previous judgments or separate or dissenting opinion, etc., just to project what the court might say and to which extent could go the court. You know, it could be very brief and could go into details regarding the question of the illegality or legality of the Israeli occupation. My last question is regarding to Susan regarding the states who voted against the establishment of the Commission of Inquiry and the referral of the case to the ICJ. Can they, under the law of state responsibility, invoke their previous positions against the composition of the Commission of Inquiry, or the referral of the case to the court to say that we objected to the referral of the case, and therefore we are not obliged to respect this opinion, and what could be the response to these states? Thank you.
Thank you. We will have another question from Taima, and then I will mention some of the questions in the chat, and then the floor will be open for the panelists to comment on this.
Thank you so much.
Taima, please go ahead.
Yeah, I'm an international relations and computer science student at Bradley University here in Palestine. And I have a couple of questions. First is for Ms. Susan. How do you navigate such a highly politicized organization or organ of the UN with only enforcement power being with the P5 in Security Council? What are the things that we need to learn from the previous advisory opinion and maybe make better or use to have more impact in that matter? And the second one is for Mr. Ralph. What is the impact of the illegality, if the court judge saw on the settlements in the West Bank? How would that advisory opinion affect the settlements and their position, which is already illegal under international law? And thank you so much.
Thank you, Taima. Before we go back to our speakers, there are two written questions. I would like to mention them as well. Then we'll take another round of questions. The first is from Patrice. So in short, the question is, what about Jerusalem in light of this discussion? The question is posed to the floor, to basically all the speakers. The status of Jerusalem in light of these findings. The second one is directed. What makes Israel sure about rejecting the court's decision or rejecting the UNGA's referral to the court and the Commission of Inquiry's findings. Please, if you would like to start answering, we may start with the same order, or if you would like to change the order, please feel free.
Yeah, let me go ahead if I can. Very good to see you again, Mutaz. It's been a very long time. You were asking about what's on the plate for the ICJ. I think some of you may know we have been holding a series of public hearings where the voices of human rights defenders can be heard directly all over the world. So these are broadcast live on UN TV, and we've held one series of hearings for the leaders of the civil society organizations that are being called so-called terrorists, and we will continue. And of course, with on the case of Shireen Abu Akleh, we will continue to hold public hearings. And as you also know, we have called for submissions for one of our forthcoming reports, which is going to be on the impact on civil society, journalists, lawyers of the occupation. So that's what's on our table right now. And of course, regarding the topic of this discussion, we look forward to contributing, if the ICJ so desires, to the deliberations on the matter. As a COI, we also have to decide how best we can intervene if necessary. But we have made it clear that we would like the court to lay out what are the legal consequences of Israel's continued refusal to end the occupation, given that, as we've been hearing, the occupation must, under international law, be temporary in nature, and the international prohibition on the acquisition of territory by force. So these are just some of the issues. And regarding Jerusalem, yes, we consider it part of the occupied territory. So, everything that applies to the West Bank would apply to, particularly to East Jerusalem. Thanks.
Thank you, Miloon. Perhaps Ralph, you would like to comment on this, unless the other speakers would like to add, please feel free.
Perhaps I can just speak about the question about settlers and settlements. So the consequence of the occupation being existentially illegal is that the occupation itself should immediately be terminated, and also the settlers and the settlements also should be, the settlers should be removed, the settlements should be dismantled. And that's an immediate requirement arising out of the existential illegality of the situation. A further related matter is the link between the existence of the settlers and the settlements, and any claim that Israel might have to use military force in self-defense. So in the legal opinion, I explain in full detail the lack of a legal basis for self-defense. And essentially, one of the main issues here, of course, is that beyond the particular episodic responses to rocket attacks, as we're seeing at the moment, the ongoing military control is understood in security terms, not as a response to actual or imminent attacks, but rather as preventative self-defense, using force to stop a threat from emerging. And part of this is, of course, using force as a means of protecting settlements and settlers, preventing a threat from emerging to them. And the inadmissibility of the doctrine of preventative self-defense in international law applies not only, therefore, to the general occupation as a means of Israel promoting its own security, but also more specifically Israel enabling the security of the settlers. And that's a very important point, because sometimes it can be missed when there is a micro focus on the particular situation of the settlers and the settlements without considering the broader context of the occupation and the illegality of their presence as it relates to the illegality of the occupation itself. A final point to make: there's sometimes a mistaken idea that because human rights law applies extraterritorially to Israel in the West Bank and in East Jerusalem, that therefore somehow settlers have, because settlers therefore are rights holders, like everyone, all human beings in that territorial area, that somehow this therefore gives them the right to remain in the territory. And as I explain in the legal opinion, this is an entirely incorrect understanding of the meaning of human rights law, which is context specific and therefore requires for its correct meaning in this context to be appreciated, the significance of the right of self-determination to be appreciated, and how that right cuts, of course, completely differently as between the Palestinian people in the West Bank and Gaza on the one hand, and the Israeli settlers on the other hand. And that's often missing from an appreciation of the meaning, the substantive meaning of human rights law when applied extraterritorially. And I would encourage all those who are applying human rights law to appraise this situation, including the Commission of Inquiry. I would encourage them to draw their attention, of course, to the fact that self-determination is part of human rights law, as well as being part of general international law. That is often missed, despite the fact that self-determination is there in common Article 1 of the two human rights covenants. And it's very important that any legal analysis of the situation that is done on an ostensibly human rights basis includes the human right to self-determination.
Thank you, Ralph. Would you like to add something, Giulia and Susan, to the...
I can perhaps take the question about the composition of the court that was raised. I haven't really looked into the court's composition and to try and predict how the court might answer the request coming from the General Assembly. But just by looking at who the members of the court are, this is an entirely different bench from the bench that ruled on the Wall advisory opinion from 2004. The only member that is still there is Judge Tomka, and I don't remember off the top of my head when his mandate comes to an end. So it's a completely different bench, and I'm afraid that, again, there will be uncertainty about what the court will say until the last minute. And I also think that the timing of the request is such that I don't see the court rushing to rule on this request for advisory opinion. So I think there will be potentially even further changes in the composition of the bench if this case is not heard until 2024. If we look at the current bench, we know how Judge Donoghue and Tomka voted in the Chagos advisory opinion, so that might be an issue. But with the new court, it's very hard to predict. I think some of the judges will be probably sympathetic and will want the court to issue an opinion and to tackle those very important questions that are put before the court. But for the other members, I think it's very hard to say. There's also the Brazilian judge that replaced Judge Cansado, that is a member of the court as of November 2022. So it's really too soon to say where he stands on these issues.
Thank you, Giulia. Susan?
Thanks very much. And yeah, just in response, there was an interesting question raised by Mutaz earlier on the kind of pushback we might see in relation to the advisory opinion. And I mean, we've seen similar pushback by third states before, like more recently in relation to the question that went before the pretrial chamber at the International Criminal Court, where there was a number of states who submitted amicus curiae submissions against the question. And I think we might see here in this advisory opinion something similar, where states are pushing back against the question and submitting positions on this, something similar, a kind of a battle being carried out within amicus curiae submissions by states. So we might see something like that. But in terms of the advisory opinion, unlike contentious cases, the advisory opinion, once it's given, will be binding. And I think it's important as well. There was another question that was asked in terms of enforcement, and obviously this is a huge issue right across the board with international law, like the question of enforcement. But this particular question is very significant because we've had the military administration itself de facto has been considered legal, and there's been no move to bring that military administration in itself to an end. So like, even in terms of all the advocacy that comes around this, like, we have an opportunity, if we get the advisory opinion on this, to really change the discourse and really change like how it really changes like the state's obligations to act. You know, they can't it can't be business as usual in relation to the occupied territory, where we're just operating on whether Israel has violated the international humanitarian law and the principles jus in bello. It'll be a completely different game changer. That is, every time we talk about Israel's occupation, we'll be talking about bringing that occupation to an end, and why hasn't it been wound down, and why aren't the forces withdrawn? And all the arguments that have been continuing the status quo, all that comes to an end. And it won't come to an end immediately, but it does carry very significant weight. And I think we have to think of all of these as all of these actions and avenues as tools, you know, like where, like the International Criminal Court, the actions taken at the International Court of Justice, the Commission of Inquiry, all of these are various different legal avenues which collectively and together over time, I think, will produce fruits, but not one on their own will be like the game changer that ends the occupation. But altogether, like we're building up like all of this jurisprudence, all of these positions on Israel and on the obligations to bring the occupation to an end, and the apartheid. And this all gives us like avenues in a different language to discuss and to present to third states. And at the end of the day, like the end of the occupation and the dismantling of the illegal occupation and apartheid regime will be probably a matter of politics, but we need to have the legal tools at our disposal, you know, to be able to ensure, you know, that states respect their obligations, and to show that third states themselves have obligations towards ending the occupation. So again, it's Everything we're doing is long term. Everything we're doing, it's a longer term strategy to dismantle the occupation and apartheid regime.
Thank you, Susan.
Hassan, can I just
yeah, please go ahead.
Can I just reinforce Susan's point? I think the times have really changed from the last time when the ICJ ruled on anything to do with Palestine. I think, as we all know, the United Nations has to forward to the ICJ all credible information available before the court, before it deliberates on the matter. And so you have, since that time, series of special rapporteur reports, treaty body concluding observations, COI reports. There's a lot of information out there, very, very detailed, and I don't see how the ICJ can ignore all that. That plus the situation on the ground. I mean, things have gotten much worse, as we all know. So I really think that the times have changed, and we will hopefully get a very strong opinion from the ICJ, advisory opinion. Thanks.
Thank you. There was a hand raised. In case it's cancelled, I would go with a written question that I have received.
Yeah, I have one question, please, Hassan, if possible.
Go ahead.
Yeah, thank you so much. And thanks to our speakers for this rich discussion, indeed, and thanks for this great attendance. So my question to you, Ralph, is about the counter argument. We know that the traditional argument in international law is that an occupation that begins as self-defense is lawful and remains so until like a negotiated solution is reached. So what is the response to that? And generally, what are the expected arguments that can be brought to the court to defend the legitimacy of the Israeli occupation? And what is the response to that? My second question to Giulia, do you think that the question formula that was referred to the court by the UN General Assembly allows it to deal with the issue of apartheid as well as the issue of the Israeli occupation being a form of colonialism, as was put in the UN Special Rapporteur Francesca Albani's last report? Thank you so much.
Thank you, Hassan. There is this written question I received a while ago. It's directed to Giulia and Miloon. So basically, the question reads as Giulia mentioned some cases where the court declined or was leaning to decline cases that it was deliberating. Was political pressure any factor in this case, such as the ICCD prioritization of the case of Palestine as a treaty? Please. So I'll take one last question from Taima, and then with this we will go to our speakers and conclude the discussion. Please
Thank
go
you
ahead,
so
Taima.
much. Yes, very quickly. Yes. What is the role? This one is for Susan. What is the role of the PA into following up on this advisory opinion and the other one on the wall? And what is and how is your work as advisor to Al-Haq restricted or not due to the last decision on having those human rights organizations marked as terrorists? Can you tell me a little bit about that and the role of the civil society into enforcing this advisory opinion if happened?
So I see no hands raised. With this, I will move to our speakers to conclude the discussion. Please go ahead. We may go with the same order we start.
Well, yeah, thanks very much. Actually, that question you read out was not very clear to me. So I don't know if it was clear to anyone else.
All right. So would you like to pass the question, or shall I?
Yeah, let me pass it. It's
all right,
possible,
all right,
so.
all right. Thank you, Giulia. Would you like to add?
Sure. Regarding the formula that were chosen for the question, I think it's broad enough that it would allow the court to touch on a wide array of legal issues, particularly also in response to written and oral submissions that will be made to the participants. And I think we'll hope that many states will want to participate in the proceedings and make arguments about Israel being an apartheid regime and there being a colonial state. So it will be much harder for the court to ignore those arguments completely, even though these words are not expressly mentioned in the question as it is phrased. With regards to the cases that were the one occasion in which the Permanent Court of International Justice decided to decline to exercise its jurisdiction, this was in 1923. So it's hard to tell whether political pressure was a factor or not. I think reading the opinion that was issued, I think that there were legal grounds that the Permanent Court cited in its opinion for its refusal to exercise its discretion to give the opinion requested. And in that case, as I said, Russia was not even a member of the League of Nations, so they had a pretty strong argument to decline to give the opinion requested.
Thank you, Giulia. Ralph?
So on the question of the international law on the use of force in self-defense, as we know, this only permits force which is a response to an actual or an imminent threat of an armed attack, where the force used here, of course, a military occupation, is necessary and proportionate to that attack or imminent threat of an attack. Now, as I said, in my legal opinion, I assume for the sake of argument that it is possible to make a case that this test was met at the stage where the occupation was introduced. But if it was not, and I leave that question open, then the occupation has been illegal from the beginning. Proceeding from the hypothetical basis that there was a lawful basis for introducing the occupation in 1967, according to this legal test, some commentators, and this is perhaps indicated in the question, seem to suggest that provided it existed at that moment of introduction, the moment of the matter of legality in the law on the use of force has been resolved for not only that moment, but also then the continued operation of the occupation. No further analysis is needed as time moves forward. So in other words, the occupation can continue without this continuation itself needing to meet any justificatory test. Therefore, it's left to the occupier to decide if and when they wish to end the occupation. A more common view is that there is a legal requirement to end the occupation, presumably because of the right of self-determination, but for the test for when the end should come is somehow something different from the general jus ad bellum test that I mentioned a moment ago. So specifically, some have suggested that the test is that the occupation can continue until there is a peace agreement. Bearing in mind that the risk that such a test could then enable an occupier to prolong an occupation by failing to make good faith efforts to pursue such an agreement, a seemingly tighter version of this approach is to say that an occupation is permitted to continue until there is a peace agreement, provided that the occupier is making all possible good faith efforts to achieve that agreement. This is not a correct description of the legal test. The requirement to meet the general ad bellum test is an ongoing one in any continuing use of force, including a military occupation. Commentators and policymakers seem to overlook that the use of force requiring justification on this basis is not simply the initial period of invasion that precedes and enables an occupation. It is also then the operation of the occupation, since the conduct of an occupation, quite separately from the circumstances of its introduction, is itself a use of force. So in consequence, the test remains on an ongoing basis, needing to establish an actual or an imminent threat of an armed attack, and that the type of force used, of course, here an occupation, being necessary and proportionate to that test. If the test is not met, which I explain how that is the case here, then the occupation is illegal, even in the absence of a peace agreement. So whether or not a peace agreement has been reached, and whether or not the occupying state is taking all good faith efforts to reach such an agreement, are not by themselves dispositive of whether or not the occupation is or is not legally justified. Thank you.
Thank you. Now we move to Susan.
Thanks very much. Yeah, and just in terms of, I just want to actually clarify something I said earlier as well in terms of the weight of an advisory opinion, which would carry like significant carry significant like legal weight, but not necessarily binding. So I just want to on third state. So I just want to clarify that. But in relation to the role of the Palestinian Authority, like we've had at this earlier stage at the General Assembly, we had the Palestinian Authority as an observer, like member state, and also other states. I present the resolution at the Special Committee on Decolonization, and that was an active role of the Palestinian Authority. And this engagement, I think, will continue as with submissions as well as the advisory opinion progresses. But really now it's in the matter of the International Court of Justice. But there's significant retaliation against the Palestinian Authority for advancing the advisory opinion, and there has been pushback by Israel and with the suspension of revenues to the Palestinian Authority as a collective punishment measure. And also listed in those collective punishment measures are kind of retaliation against human rights organizations and civil society organizations who've been doing advocacy on this issue as well. And we would imagine that Al-Haq will come into the firing line for that, because Al-Haq, along with other Palestinian human rights organizations, were very active on the lead up to the General Assembly resolution in doing advocacy, like with third states, to push for support for the advisory opinion. In terms of the designations of Al-Haq as an alleged terror organization under Israel's counter-terrorism law, and these are grounds which are completely unsubstantiated and have been completely decried as incredible and not credible and not based on any evidence by states of the European Union and many third countries. And And we've had like overwhelming support from other civil society organizations as well. But there is, of course, a chilling effect and a kind of a dagger hanging over our work with the consequences of that. And of course, it's only a few months ago that our general director and the general director of Defence for Children International were threatened with arbitrary arrest and detention for continuing on with the human rights work. So we do have this hanging over the organisation. Those designations still stand. And the more we advance our work, and the more we advance our work at the Commission of Inquiry, the more we advance our work around the advisory opinion, and especially as well around the International Court of Justice, the International Criminal Court, we become more susceptible to attacks and raids by Israel, and our staff are also under threat. So it does have impacts behind the scenes, but we are absolutely committed to our mandate to try every legal avenue and all peaceful and legitimate means and all human rights avenues for the full realization of the self-determination of the Palestinian people, the right of return of the Palestinian people as a whole, and the dismantling of the cruel apartheid regime and the dismantling of the illegal occupation.
Yeah, Hassan, I just wanted to say that, I know we're talking about the ICJ potential advisory opinion, but while we wait for that, I think we all in our own capacities have to continue to do what we expect, the ICJ to do, which one of the issues is third state accountability. And I think a point the COI has been continuously raising is the issue of double standards, particularly given the response of the Western states to Ukraine. So the duplicity and double standards, I think we need to continue to hold third states accountable, and we need to continue to push for, as Dr. Wilde is saying, the issues of settler colonialism, general issues of non-discrimination and self-determination. I mean, this is one of the issues, one of the reasons why COI has not yet spoken out on apartheid, because we think it's a much more complicated scenario. So just to say that all the work has to continue while we wait for the ICJ opinion. Thank you very much.
Thank you so much, Miloon, for this. With this, I would just conclude the discussion. The UN Commission of Inquiry and Mr. Kothari concluded that there was a perpetual occupation and that it's unlawful under international law. Dr. Giulia as well sees no compelling reason to decline the case, and she doubts the court will reach a different conclusion than the Commission of Inquiry, if I rephrase it correctly. Ralph puts it simply that there is no necessity or justification for prolonging the occupation, and every day of its continuity is a breach of international law. It is illegal in existence and conduct, as he phrased it, which means that this leads to the prohibition of aggression, even if it is quoted in the form of self-defense. Susan brought our attention to the other similar examples where third states were obliged to respect the rulings and not to recognize the status quo or be a complicit in its illegality. It is imperative in this case that third states respect their responsibility, and that the ICJ demands concrete action. Now, with this, I would like to thank our speakers, our audience here in this Zoom room, and on those watching the live stream. I would like to thank our interpreters, Malik Tiraniya and Ammar Akash, for the simultaneous interpretation into Arabic. And with this, we conclude our event. Thank you so much. And apologies for exceeding the time. It's been 7 minutes more than the time, the planned time. Thank you.
Thank you so much.
Thank you.